Today, July 12th, 2025, Washington, D.C. In a landmark shift that may impact thousands of immigrants, a newly released internal memorandum from United States Immigration and Customs Enforcement outlines plans to deport individuals to countries where they are not citizens. Even in the absence of formal safety assurances from those countries, the memo, authored by Acting ICE Director Todd Lyons and circulated on Wednesday, follows a June decision by the Supreme Court that allows deportations to proceed without requiring procedural safeguards previously mandated by a federal judge. In the document, Lyons instructs immigration officers that deportations to alternate nations may begin immediately, in some cases providing as little as 6 hours' notice to the affected individuals. The guidance permits deportation without prior diplomatic guarantees of safety from persecution or torture, although migrants sent to nations that have offered such assurances may be removed with no advance warning at all. According to Lyons, if the U.S. State Department considers these assurances credible, no further procedures are needed before removal. In a strongly worded dissent, Justice Sonia Sotomayor warned that the policy disregards life or death consequences. In matters of life and death, it is best to proceed with caution. In this case, the government took the opposite approach. The Lyons memo confirms that ICE has already removed individuals under similar procedures. Notably, immigrants from several countries, including Venezuela, Myanmar, Laos, Sudan, and Cuba, have been sent to conflict zones such as South Sudan, despite diplomatic tensions or a lack of safety guarantees. Under the updated procedures, ICE may notify individuals as little as 24 hours in advance, and in emergency situations, just 6. Those who express fear during that window may undergo screening for humanitarian protection under federal statutes and the Convention Against Torture. However, Lyons' memo does not mandate officials to ask if the person fears persecution in the third country, a point critics say violates the principle of non-refoulement. Although immigrants must be allowed to consult with legal counsel, the memo states this must only be reasonable under the circumstances, and final authorization must come from the Department of Homeland Security's top legal advisors. DHS and ICE officials have not responded to public inquiries about how many immigrants could be impacted by the policy shift or whether additional safeguards will be implemented. This change marks one of the most aggressive immigration enforcement maneuvers in recent U.S. history.